I was at the Pacific Internet Governance Forum, and the then chairman of ICANN, Peter Denge Thrush, was there. And this was before the announcement of the new domain system was out there. And at a drinks party after one of the sessions, one evening while we were there, we had a discussion, about 10 of us sitting around. Who would have the right, or who would be best suited to operate the .god domain? Who could register it? Well, as you see, it says .god, so it has to be a monotheistic religion to start with, so that cuts out some polytheistic religions right away, unless you thought of it as .gods, and then you could have two domains. A discussion ensued, well, if it is .god, which of the monotheistic religions would get it? Well, someone put up their hand and said, well, obviously the oldest monotheistic religion that we have, Judaism. And someone else in the audience or in the group said, no, not really, because if you look at the Ten Commandments, it says, thou shalt have no other gods before me. So it wasn't, it didn't say that there weren't other gods, it just said that I'm the main one. And so I mean, it has evolved over time differently. The point is not to have a theology discussion, but to get into some of the problems of sorting out who's going to have rights over some of these domains. And it was an interesting discussion. It was kind of a fun discussion, but it pointed out to me the seriousness of a simple concept being implemented and how difficult it's going to be and what a hard job ICANN is going to have in sorting these things out. Okay, let's get back to the human rights part. So here's the main human right that we're talking about. It's Article 19 of the Covenant on Civil and Political Rights, and I've highlighted the pertinent parts, that there is this right in the first paragraph. The second paragraph then carries a number of exceptions to it. The right is not absolute. There are certain things where we can derogate from the right, but it's a right. And we'll see how in other areas, in other domains, the same structure appears. So a statement of the right or the statement of the objective, and then the exceptions to its application. Here we go. So if you break down that schema, you have the restrictions, and then further how you would interpret those restrictions. So there have to be certain elements involved: predictability, transparency, proportionality, et cetera. And we'll see then how these rights pop up in other places. Again, the human rights dimension in internet governance and cybersecurity has percolated right up to the top. It's at the top of everyone's discussion list right now. And the most recent international, or I guess regional, example of this emanates from the Council of Europe, which issued in September of last year a statement, 10 principles for internet governance, and this was principle 9, I think. The Council of Europe is, does everyone know about the Council of Europe? Okay, take a couple minutes on that. Council of Europe is not the European Union. It's a different organization. It consists of both EU members and non-EU members, about 43 countries, I think, by last count, 44, something like that. They are primarily a human rights organization, so they promulgate instruments for the protection of human rights. One of their main instruments is called the Budapest Convention on cybercrime, which is an internationally recognized document or instrument. They also periodically, through their Council of Ministers, issue certain things, and this declaration was issued last September. And if you look at it, it's net neutrality in disguise. It doesn't say anything about net neutrality the way that we understand the debate in this country, but if you look at the highlighted portion in the second paragraph, it provides that traffic management cannot impinge on these human rights. And it then goes through what the right is. It's that right to receive and impart information. So if you think about the members who are of the Council of Europe, it includes Russia, includes the UK, includes Moldova, lots of countries who have different views on things, but this is a consensus document that was adopted. And it's, I think, a very, very important statement. Now, for those of you who might be representing business clients, you'll see immediately the intersection of what would really be seen as kind of an economic activity, net neutrality, monitoring traffic, something like that. You see the relationship between that and human rights. So imagine the case, and this is kind of my nightmare scenario at work. If we give advice to a country, say Egypt, about a legal framework that would include something like net neutrality. Imagine that we had given that advice prior to the Arab Spring, and that then the World Bank had been involved in a traffic management system when the internet was shut down and people couldn't use the internet for a few days. As a legal officer responsible for legal reform in that area, I would be horrified that something that would be considered a technical issue, well, we don't want people to download too many movies because it's too expensive, it clogs up the traffic. We wouldn't want what on its face is a technical issue to then be used to suppress political speech. Now, fortunately, we didn't give that advice. We weren't involved in that. But you can see how making certain decisions, if you look at these issues very discreetly or in isolation of other issues, can have impact elsewhere. And so this, to me, was very welcome on the one hand, but also demonstrative of the interrelationship of these different things. We've talked about that already. And that. We also are looking a little bit at some other aspects of intellectual property. This happens to be about counterfeit goods, and I don't want to spend too much time on that because I think we've got some other things to talk about. Okay, let's move on to .privacy. Now, there are two very recent events that I think will be important in the privacy area going forward. One was, after a long delay, and the issuance by the European Union of a series of documents in January. Now, without going into too much detail about EU law, there's been a privacy directive in place in Europe since 1995. And without belying my age too much, when I was in private practice, I was based in Brussels for 5 years and worked with our clients on that privacy directive, which was issued in 1995. That's been a pretty robust instrument in Europe. The way the directives work generally is that they're adopted at the EU level by the Commission, and then each country is supposed to transpose those directives into national law. So the directive is kind of like guidance. And as a result, what happened in Europe was you had lots of different countries with lots of different approaches to privacy. The principles were all there, but the application was different. And what happened was that there were sort of better places for privacy and not so good places for privacy, even within the European construct. And the Europeans are very, very concerned about what they call the single market. Not too much different at a certain level from our concept of federalism and why we have the Commerce Clause. But what resulted was that you had these different pockets, and people didn't know how to comply even within Europe if they had operations in different countries because of the different country laws on privacy. So one of the things that this new set of documents is aimed at doing is to resolve that, to introduce harmonization, and to replace the directive with a regulation. Now, a regulation, by contrast, is not adopted by the Commission. It's adopted by, I think, the Parliament, the European Parliament. In any case, a regulation applies as it is mandatory. So they will have achieved harmonization in privacy. A couple of key features that arose out of this set of documents, and there's a consultation going on now, is there is increased responsibility on data collectors, data processors. They have certain additional obligations with respect to the data subjects, the individuals. Correspondingly, there are enhanced rights for individuals, including one that's been suggested, and I think someone on tomorrow's panel is talking about, or is it later today on privacy, the right to be forgotten. I won't preempt that discussion, but it's a very interesting and controversial issue because while one could see in certain circumstances that I really regret that Facebook posting that I did and I'd like to take it down, I'd like for people to forget that. There are certain data that governments, policymakers don't want to be forgotten, like a criminal record. That shouldn't be wiped out at the discretion of the individual. So there are some issues there that need to be sorted out. Another important concept being introduced is the notion of data portability, which allows the individual, if they're using a certain provider like Facebook and then want to quit Facebook, to move all of that data all of their data to another social media network. Sounds good in principle, I think probably very difficult in practice. They've also adopted this concept of privacy by design, or they've introduced the concept of privacy by design. Privacy by design is a concept that emanated from Canada and that has been now adopted really all around the world. And it really is this sort of user-centric, rights-based approach to privacy. There's, if you go to the Privacy Commissioner of Ontario, I believe it is, they have a whole privacy by design information sheet, and you can explore it more there. They've also made extraterritorial application of the regulation part of it. So if you're a US company and you happen to be trading in Europe, their long arm can get you. And that is backed up by pretty severe penalties. So if there's a breach of these new provisions under the regulation, penalty is 2% of global turnover. That's a pretty big number for some companies, and pretty important. Probably not coincidentally, about 2 weeks later, the White House issued its paper that I have here. Very nice paper. And in it, they covered some of the same ground. They recognized that there are certain things like HIPAA that apply in certain areas and other sectoral laws that already exist. So this paper doesn't address any of that stuff. What it's meant to do is cover the gaps that are in between as far as it relates to consumers, and they've gone to some length to define what consumers mean. To me, interestingly, they've already punted on the legislative thing in the paper. They said, well, you know, in case there isn't legislation on this, we'd still like to have some enforcement, so we're going to encourage companies to get codes of conduct, and then we're going to give the FTC some enforcement power. We hope there's legislation, but if there isn't, we can deal with it. But again, it's enhanced rights for individuals. Doesn't go, in my view, quite as far as the EU set of documents do, but it gets there. And so what we see in the end is maybe, I don't know if you can see it behind the table, but at the bottom there's a word convergence with a question mark.